Hello, I'm David Johnson with ACM Partners, and today we're going to talk about out-of-court restructuring for middle market companies. Since the 2005 Bankruptcy Code change, middle market companies within the United States have faced exploding costs for Chapter 11 bankruptcy. As a result, distressed middle market companies, especially those in the lower middle market, that being companies with sales below $250 million, are finding it best to restructure out of court. There are many advantages to restructuring out of court, but two of the key ones are control and cost. While the United States Bankruptcy Code is one of the most debtor-friendly in the world, it is undeniable that management will have more control over a restructuring process out of court than it would within. Additionally, Chapter 11 bankruptcy mandates that companies pick up the cost of professionals for creditors, which means a company seeking to restructure within court would need to not only pay its financial, investment banking, and turnaround advisors for itself, but also those of creditors, and occasionally unsecured creditors as well. This results in somewhat of a fee bonanza for Chapter 11 proceedings, which is ruinously expensive for small and middle market companies. Despite the advantages, there are disadvantages to pursuing an out-of-court restructuring. And one of those is the need for management to sell the plan. There is no mechanism in an out-of-court restructuring for compelling your creditors to come along. It is incumbent upon management and its advisory team to craft a sufficiently attractive plan to get creditors to back it. Additionally, an out-of-court restructuring has no formal legal protections, which means a company should expect that any liquidity stresses, any problems with vendors or landlords will continue. The crisis will not abate until the restructuring is finalized. On balance, out-of-court restructurings offer the best risk-reward profile for distressed lower middle market companies. Increased management control and lower professional fees can be game changers for these organizations as they seek to reposition their business. Despite this, there are disadvantages, and because of those disadvantages, an out-of-court restructuring is most appropriate for companies with simple capital structures and a limited number of lease obligations. As founding partner of a turnaround and restructuring advisory firm, I have worked with middle market companies seeking to restructure both in and out of court and successfully restructured over $5 billion of debt. It is crucially important that advisors, managers, and equity sponsors seeking to reposition their distressed companies take full account of the advantages and disadvantages of the venue in which they choose to restructure. I'm David Johnson. Thank you.